Good evening, everyone. I'm Rebecca McLeod from What's Macrae. Thank you for joining us tonight for a webinar in regards to the general law and processes of a family law property settlement. We advertised that my colleague Kathy Chase would be joining us tonight. Unfortunately, she's sick as a dog. I've had my other colleague, Janine Goodwin, kindly put her hand up to help out. Kathy is here and listening, but she can't finish a sentence without coughing. So apologies about that, but you get a pretty good runners-up prize with Janine. So I'll introduce you to Janine later on in the evening. I'm going to get cracking straight away because there's quite a lot of content that I'd like to get through to tonight. And I'll just take us through now to the proposed agenda for tonight. In one sec. There we go. Sorry, back a step. A little bit of background about who we are as a company and who we are as individuals. So we're employed by What's Macrae. What's Macrae has been around for over 40 years and are very well known and respected in the family law field. We help with anything and everything family law. That's our jam. So whether it's a property settlement, a parenting matter, child support, spousal maintenance, urgent recovery orders, you name it, anything that's a little bit left of field, surrogacy, adoption, prenups, we practice exclusively in family law. So we're prepared to touch some of the things within the banner of family law that some firms don't. We have the resources and the brain power, respectfully, to be able to do that. A little bit about myself. I've been practicing for the 15 years now, and of which about the last 10 has been predominantly in family law. To be really honest, I fell into it. When I was a junior solicitor, my boss at the time hated family law and it got thrown to me, and as a junior, you take on whatever gets thrown to you. Happily, I found that I really enjoyed it. I really like being able to help people who are in a difficult situation, and I just really like the human element about it. So, yeah, I was happy that came about. I'm Northern Beaches born and bred, be it a good thing or a bad thing. I haven't left the Northern Beaches my whole life. So not saying that we all fit a box, but I do know our demographic and I do know our lifestyles. And I think that probably brings something to the mix as well. A little bit about me personally also. I've got a young family. So when we're talking about parenting matters, for example, I know what worries people might feel if, they've got some concerns around parenting arrangements that they might not feel particularly comfortable about. So I think I can bring some personal empathy to the mix in that regard. A bit about Kathy. Apart from being sick as a dog, she's very experienced. She's got over 45 years of practicing experience, of which about the last 35 of which has been predominantly and heavily in family law. She's got a Master's of Law, specialising in dispute resolution. She's also such an expert that the College of Law, who teaches lawyers, asked her to come and teach lawyers how to be better family lawyers. And so she went and did that as well. She's been on the Northern Beaches for about the last 39, 40 years, and she is a very proud mum and grandma. Janine. Janine's been admitted as a lawyer for 12 years. She's had a little bit more of a varied experience, which is helpful because family law matters often involve, for example, trust issues or tax issues or property related issues. And coming from a generalist background, it helps to bring some things like that to the mix. So she's got experience clearly, obviously, in family law, but as well as estate planning, which enables us to help you with wills as well, because that sometimes spins off as following a separation, as well as civil litigation, commercial and property law. Janine's been on the beaches for the last 24 years and she too has a young family. Tonight's agenda. So tonight is about giving some general information around the law that surrounds a family law property settlement and the process. Just as a heads up, when we were thinking about what to present tonight, I thought that this might be helpful and relevant, but I was thinking, oh, there's probably people that want to know about parenting information as well. And so I do intend to do a second webinar on parenting matters. But just to be clear, tonight we're just tackling family law property settlements. After I've done that, I'm going to invite Janine to present a hypothetical fact scenario so that hopefully we can see the explanation of the law and the process play out into a hypothetical. I am going to invite people to ask their questions at 3 points in tonight's presentation, but I will do that at 3 points just so that we can sort of keep things running a little bit smoothly. So after I've explained the law, I'll then stop at that juncture and invite any queries. Similarly, after I've explained the process, I'll invite questions at that point. And then after Janine explains the hypothetical, the way you go about asking questions, hopefully you can all see the comments tab on your screen. So it's a matter of please typing in those questions and we'll loop back to them at those 3 junctures. Feel free to type the questions in as and when they come to mind, but I'll just loop back to them at those points in time if that's okay. I then now need to say that please be mindful that what we're talking about tonight is not intended or to be construed as legal advice. And there's 2 big reasons for that. We have to give tailored advice. There is no one size that fits all. And so if you take something from tonight and think, oh, well, that applies to me, that's a bit dangerous because, as I said, no 2 cases, no 2 families are the same. And so it can't be specific advice. So if you do ask a specific question about your particular situation, I can't answer that respectfully. Obviously, if you'd like to contact me outside of today, I will happily assist. And that segues on to my second reason as to why that would be tricky. We haven't vetted tonight's audience, and for the sake of protecting the interests of the clients that we're currently acting for, I don't want to say something that potentially is in conflict or jeopardizes my client's position in answering a question tonight. So I hope you'll understand and appreciate why I might come across evasive in some questions. That's where I'm coming from. Okay, so sinking our teeth now into the actual formula. No one wants to end up in a courtroom. It's expensive, it's stressful, it's meant to be quick, it's not. It just makes lawyers wealthy along the way. The goal is always to try and reach a reasonable agreement as quickly as possible. That being said, there's a time and a place for litigation, and it's there as a backstop if you need it. So when I talk about what does the court do, what does the court do, what we as lawyers are doing in advising our clients is pretending to be judges and saying, right, if this matter was being presented in front of us for a final determination, what do we think a judge would say is a just and equitable division? So please keep that in mind when I keep saying the court, the court. So at the moment, the courts use a 5-step approach to determine what a fair division of an asset pool is. The first step is to say, should we even weigh in and talk about moving assets around for these parties? Is a property division just and equitable? Moving on to the next slide that unpacks that. The court's only going to weigh in and make property adjustment orders if they consider it to be just and equitable to do so. It's probably easier to define when it would be not appropriate to do that than when it is appropriate to do that. So an example of when it isn't appropriate to do that would be, for example, quite a short relationship, maybe of 2 years, no kids, and the parties kept their assets separate. There would be a relatively strong argument there to say, if one party didn't want their assets pursued, to push back and say, no, you don't get over the first hurdle of the court even having jurisdiction or it being appropriate for property adjustment orders to be made. So that's our step 1. Moving on to step 2, the court then identifies what the asset pool is available for division, because it's not necessarily pointless, but it becomes a bit of a nonsense to talk about hypothetically an overall 60-40 division of what. We need to understand what it is that we're talking about dividing. So in terms of the asset pool available for division, we're talking about all the assets, so realty, cash, savings, cars, businesses, companies, privately listed shares, publicly listed shares, crypto, art, tools, jet skis, it's all in there. Similarly with liabilities, mortgages, tax debts, personal loans, family loans, that's a really common one in family law. Super. Historically, super was treated differently in a family law matter, but for a long time now, super's in the pool. And then finally, financial resources. So a financial resource is something, it's separate and different to an asset. The best example of a financial resource is an interest in a discretionary trust that a spouse doesn't have control over. So the concept is you're being financially propped up by something, but you don't have control over whether or not you receive a cent or $1 million. The court will recognize that you've got a financial resource in someone or something. The value of that trust in this hypothetical doesn't hit the bottom line value of the asset pool, but it will become relevant to the percentage division that is just and equitable in dividing that asset pool. Critically, it's irrelevant whose name an asset or liability is in terms of between husband and spouse or corporate entities related to husband and spouse or trust. And it's irrelevant what country it's in. That being said, if we've got assets overseas, it can be logistically challenging to enforce orders against them, but that doesn't mean that if, for example, there was, I don't know, cash in Brazil or something like that, that it wouldn't be included in the matrimonial asset pool available for division. So when we're crunching our numbers and working out percentage divisions, it's acknowledged that one of the parties has got, I don't know, the equivalent of 50,000 Australian dollars in Brazil, and they'll be retaining that. So whose name it's in, doesn't matter. Moving on to our step 3. Third step is to assess the contributions that the parties have made. Now, there's 4 different types of contributions, and they all have the same weight. There's no hierarchy, and I am going to unpack and explain each of those. Those 4 different types of contributions are financial, non-financial, homemaker, and parenting. In unpacking each one of those, looking at financial contributions, it's pretty self-explanatory, so I won't try and bore you all, but I'll give some examples of what a financial contribution is. And critically, the court looks at financial contributions at the time parties start living together, at the date of cohabitation, during the relationship, and then post-separation. So they'll be looking at things such as the initial contribution. So quite often that's more relevant in perhaps a second relationship where one party might have maybe wealth, maybe the other party doesn't. And if there is a disparity in that regard, it's one of the factors that is relevant to when a court's working out what is a fair division. Then sort of moving on to assessing financial contributions during the relationship. Income, be it from the traditional method of, salary or your job, or perhaps it's investment income. Maybe you've got an investment property, or maybe you've got shares, publicly listed share portfolio that generates an income, but income in general. Contributions to the acquisition of property. So really obvious one there is you've bought real estate and maybe you've chipped in 100K towards the purchase price or paying down the mortgage or something like that. Again, contributions towards property, the court will recognise maintenance of the property for general upkeep. In a similar but different flavour, contributions towards the improvement for property, so funding renos, paying for those renovations. The other type of financial contribution that the court's interested in is what they call windfalls. I call them wins. They're things such as inheritances, gifts, lotto wins, redundancies, compensation payouts, etc. So the court wants to know, it doesn't necessarily have to be lump sum monies. It typically is lump sum monies. It's legally relevant in terms of when a court's assessing the contributions that have been made by parties. The court recognises that there's a difference between direct and indirect financial contributions. An example of a direct contribution are all the ones we've just talked about before. You've For example, you've contributed 100K towards buying realty. An indirect financial contribution would be, for example, maybe the parties lived with the husband's parents rent-free for a couple of years or something. You guys have saved money by doing that. The husband's parents having provided, for example, 50K towards putting rent or something like that, but they've helped you save money by providing that indirect financial contribution. So both count. Moving on to our second type of contribution, non-financial. This one's less obvious, and I colloquially call it the blood, sweat, tears factor. The general concept is that you're not dipping in your pocket to pay for something, but you're doing something off your own time, labor, or skill to increase the value of an asset. The most classic example, and certainly not the only one, are renovations. Critically, it's the parties themselves doing the works. So, for example, painting, adding a pergola, landscaping, you're physically doing that work yourselves. More of a white collar example might be helping run the books for a company, a privately owned company is what I'm trying to say. And I've had a client previously, he was a real estate agent and he used his know-how to buy and sell, and that accumulated quite a lot of wealth for the family. So we deem that a non-financial contribution. Okay, next type of contribution, homemaker contributions. This is everything that takes to keeping a household humming. Cooking, cleaning, laundry, grocery shopping, paying bills, gardening, pools. There's no one size fits all for every family. It's always a matter of asking a client to say, tell me what it looks like in your family. Is it, I don't know, the traditional, I took care of the inside, he took care of the outside, or whatever it is. It's important to understand what that is for each and every client, because again, it's not the same across any two households, but critically, the court considers that legally relevant. That takes us to our fourth type of contribution, which is a parenting contribution. Clearly, the nature of what's called upon as a parent is different depending on how old your children are. It's all relevant. It all counts. So obviously when it comes to babies, it's keeping them alive stuff, feeding, changing nappies, settling through the night, taking to medical appointments, bathing, playtime, reading to them, etc. As the kids get older, their needs change. So it might include things such as buying more clothes or enrolling them in extracurricular activities or researching schools. The mental load of parenting counts as well, and who's taking care of that. Obviously, as kids get older, then you've got carting around to play dates and umpteen extracurricular activities, which is the Northern Beaches way. But all of that, helping with homework, all of that is considered legally relevant in terms of the contributions that have been made by the parties. I'll just point out now also in our society where, there is no traditional family, stepchildren and parenting of stepchildren is also recognised as a parenting contribution. Again, it depends on the degree and amount of time you're spending with that stepchild and what you're doing, but it certainly can be recognised as legally relevant. Okay, so that was us unpacking the 4 different types of contributions. Now we're jumping back to our step 4 within the process of a court determining what a just and equitable division would be of the asset pool, which is assessing the future needs of the parties. Under that banner, there's a section in the Family Law Act, and it lists a myriad of factors, and they include the age and health of the parties, the income and financial resources, the physical and mental capacity for employment. And the word capacity is quite important there, because if you've got a master's in business or something like that, and you're choosing to just work at Woolies, all the power to you. But the court will say, well, you're qualified to be earning more than that. And so even though the other party is earning more than you, you could be earning more. I've unfleshed that one or unpacked that one a little bit more, because it does come up more often than you'd suspect probably. The other one that comes up quite regularly in terms of assessing the future needs of the parties is care of kids, because the court recognises that in itself takes time and takes away from all, it has an impact on your time and what you can commit to in terms of work. In addition to a reasonable standing of living is an interesting one, and you don't often see it too often, but the gist around that one is if you've been lucky enough to enjoy quite a luxurious lifestyle or comfortable lifestyle pre-separation, the court will say, well, if there's the means to do that post-separation and there's enough wealth in the asset pool, then we'll entertain you being able to continue that lifestyle. Care of other family members comes into the mix. So, for example, if you had elderly grandparents or something, elderly parents or grandparents, and you were physically caring for them or something like that, again, it comes under that banner of future needs. Just to unpack the age and health point, which is our point number one, because again, that tends to be something that's more so relevant. The age factor is more so connected to whether you're triggering retirement. So if hypothetically we had a 60-year-old and a 40-year-old, or I should say a 65-year-old and a 45-year-old, the 65-year-old would say, well, I'm going to be retiring soon. I don't have, 20 years left of working in me like you do. Whereas conversely, the 45-year-old would try and say, true, but you can tap into your super. So depending on if there's enough super there, that's kind of how the age argument comes into play in a future needs adjustment. On the health side of things, that's probably self-explanatory, but just to be clear, it's not just it's health in the context of A, whether it costs you money to manage that health condition, or B, maybe it's as well, B, does that impede your ability to generate an income? So these things need to be proven. You can't just willy-nilly say, I've got a sore back, I can't work, obviously, and the level of proof that you require depends on where you're at in your family will matter. And, if the other side says, I know that she did have a big bad back or something like that. So these are all the types of things that come into the mix under considerations of future needs of the parties. Moving on to our fifth and final step, the court then steps back and says, right, is the proposed division of our net matrimonial asset pool just and equitable? That's the terminology that the law uses. It's really airy-fairy. It's a discretionary area of law, which is why it's impossible for any lawyer to tell you with any guarantee what the outcome of a court case is going to be. Our firm always talks in ranges of entitlement. So, for example, we might say, look, if you were able to negotiate an outcome that saw you receiving, say, 55 to 65% of the asset pool, that could very well be the outcome of your case if you were to run it to a final hearing. So if you can reach that outcome by agreement now, then you remove the uncertainty and you're probably winning. So please keep in mind that family law is a discretionary area of the law. So for that reason, there are no certainties. It's our job, obviously, to try and give some parameters around that, but it's not an exact art. So in saying, when the court's saying, is that proposed division just and equitable, they're stepping back and saying, right, hypothetically, is a 60-40 division just and equitable? So they're looking at the percentages, but then they're also looking at the nature of the assets that the parties are retaining. So I always give the silly example to try and make the point of saying, if our asset pool hypothetically was $1 million in super and $1 million in cash, party one was keeping all the cash, party two is keeping all the super, the court would say, well, that's not fair. The party that's getting all the supers, their wealth is locked up until the preservation age, whereas the other party's got liquid assets now to rehome and do whatever they like. You both need a bit of both. So that's what's coming into the mix under just and equitable. And as I put there at the end, simply put, is it fair? Okay, so that's a legal formula in a nutshell. That's how a court would tackle a family law property settlement. I'm going to pause at this point now and invite you guys to fire any questions at us. So I know how tricky it can be to sort of type things as you're hearing things. So I'll just allow 2 minutes for that, and then I'll move on to explaining the process. Okay, I've got a question here, and I won't name names in case people want to stay anonymous. The question is, if I've built super up abroad in your own name before I got married here, assuming you're meaning Australia, can I not declare that and keep it? No, is the short answer. If you remember the slide where we were talking about identifying our asset pool, it's irrelevant whose name the asset, including super, is in and the country it's in. So, sorry, no, it's in. I'll just give a little bit more time for more questions. Okay, look, I'll move on. Please feel free to type in any questions as and when they come to mind, and it doesn't have to be exclusively on the next step of process. Feel free to fire any questions at any point in time. I will loop back to them at 2 separate points from here. Okay. Moving on now to the process. So it's all very well and good to understand the legal framework. How do you work it out? How does it get implemented? How do we get to where we want to be? The process around working out a division of an asset pool is pretty streamlined, or pretty simple, I should say, or should be and could be pretty simple. The first step is to exchange financial disclosure. The Family Law Act requires that. It's legally mandatory. There's no getting around it. If a party refuses to provide it and you find yourself in a courtroom, the court will come down on you like a ton of bricks, because how on earth can anyone negotiate in an informed manner if they don't have all the relevant information? So financial disclosure is the sensible first step so you can negotiate in an informed manner. Sorry, I've forgotten the order of my slides here. I've actually got slides that unpack each of them. So the intention was, at this point, I'm going to briefly explain the process, and then I'm going to unpack each point. So we've just talked about financial disclosure. Thereafter is the negotiation phase. After that, hopefully we've reached an agreement, and then we embody that agreement into something that makes it legally binding to give it some teeth, and then we implement our agreement. So I've unpacked disclosure a little bit. So again, just confirming, you've got a legal obligation under the Family Law Act to provide full and frank financial disclosure. An example of what that entails and what that involves is asking for an exchanging, and it goes both ways. Both parties need to provide the documents. Pay slips, bank statements, super statements, company tax returns, personal tax returns, company financial statements, help debts, loan agreements, long service leave entitlements, everything. It all needs to be provided. Financial resources, frequent flyer points, credit card points, etc. And to loop back to that question there, and to reiterate the point, disclosure isn't just limited to assets in Australia, it's worldwide. By exchanging disclosure, that helps us form what we call in the family law world a balance sheet. A balance sheet is essentially a legal jargon for a schedule that sets out the assets, the liabilities, super, and financial resources. It's user-friendly in the sense that it's got the description of what those relevant things are, excuse me, and then a column that says applicant's asserted value, respondent's asserted value, so that we can identify. So if hypothetically it was the family home in, say, Narrabeen, The applicant says, I think it's worth 2.1. The respondent says, I think it's worth 2.3. We go and get 3 market appraisals. And if we can't put the issue to rest by doing that process, we go and get an expert valuation and we determine that it's worth 2.2 or whatever it might be. So it helps us identify what's agreed and what's not agreed in terms of our definition of the asset pool, because again, when we're talking about the overall division, we need to make sure that we're talking apples to apples, because if the applicant's saying, look, my offer to you is for me to retain 60% of the asset pool, if you're defining the asset pool as, for example, the house is worth 2.1 and you're buying the other party out at 2.1 and they think, well, you should be buying me out at 2.3, it's really critical that we're literally on the same page in terms of the asset pool that we're talking about in dividing. So that's, again, why financial disclosure is critical. Moving on to the negotiation phase, there's no rules around how that's done. Plenty of clients will say, look, give me the information, and to empower myself to have a go at doing that myself. So they might choose to do that themselves directly and then come back to us once they've reached an agreement to make it legally binding. You might say to us, look, can you help us with that process and exchange some letters with the other side for us? So it's written negotiation, essentially. A roundtable conference where that might be, if there's lawyers involved, spouse 1, spouse 2, spouse 1 solicitor, spouse 2 solicitor, and we come together and nut it out in lifetime. Or the more formal option around that is a formal mediation. In the family law world, we call that family dispute resolution. It's mediation essentially, but the mediators are specifically trained in family law matters. The court requires parties to have participated in mediation before commencing proceedings, unless there's urgency or domestic violence, etc. But in terms of how you negotiate, I will always say to a client, look, these are the options. What sits most comfortably with you? And they might say, look, let me try talking to my ex directly and I'll come back to you if I need some help. There's no harm in doing it that way. And it might be that we go straight to a round table and then we continue on with letters, etc. So a combo of all of the above. Okay. Next step, hopefully we've reached an agreement. Once we've reached our agreement, there's 2 ways in which you can make your deal legally binding. The first one is to put it into consent orders, and the second one is called a binding financial agreement, which people in the family law world refer to it as a BFA. So if I say BFA, binding financial agreement. So consent orders, the gist of consent orders, the name's pretty indicative. The orders that the parties enter into by consent, you lodge that with the Family and Federal Circuit Court together with an application for consent orders. And the application for consent orders is kind of like a questionnaire where you give a whole lot of information, but part of that information is the story around the contributions and the future needs. Because when the court's looking at your proposed orders of, just hypothetically, 60-40 with the husband keeping the property and paying the wife out, for example, they're not just rubber stamping your orders. They are reviewing the particular facts of your case to say, well, yeah, we agree or we don't agree that that division is just and equitable. So it's not just rubber stamping. In my experience, the courts love it when people agree, because the less people that are getting bogged down in the court system, the better. So, and again, being a discretionary area of law, the courts are generally loathed to knock back orders by consent, but it does happen. It has happened to a couple of matters in my career. So in some respects, that might be a good thing, because you're like, oh, okay, well, I have a safety net in that the court won't make the orders if they're not fair. Costing around it, the court charges a filing fee of $180, and that's typically split 50-50 by the parties. So quite affordable time frame around it. In my 15 years of practice, it's varied from as long as 3 months to hear back from the court and as long as 3 days to hear back from the court. Thankfully, we're at the 3 days phase at the moment, so it's pretty quick in terms of lodging those orders and waiting to hear back from the court. So That leads me now to option number 2. Option number 2 being that BFA, binding financial agreement. It's a contract, essentially. You're contracting and committing to say, well, I'll keep the home and pay you a cash adjustment of X, Y, Z. The concept of it's really simple, but the law around binding financial agreements is really technical. And for that reason, a lot of firms and solicitors are hesitant to touch them because there's too much scope to set them aside if they're not done properly, which is why we do them. But if there's an option to do consent orders, we always suggest to our clients to do that. I guess the only scenario that I would be encouraging a client to do a BFA over consent orders would be if the deal was so fantastic to them and I thought, oh, the court's not going to accept this. It's a calculated and sensible risk to go with BFA, and let's do it properly and make sure that we meet all the technical requirements. That would be a sensible scenario, but otherwise, consent orders are the way to go. Okay, then we get to document. We've documented our agreement, then we need to implement it. Whatever the implementation is, there's obviously that's applicable to that particular matter. So it might be selling a property and divvying up sale proceeds. It might be transferring a home from joint names to one party's name. It might be bowing out of a self-managed super fund. It might be bowing out of a trust or a company. It might be taking over a family loan and indemnifying the other party. It might be transferring rego of a vehicle. It's our job to draft the orders with sufficient clarity and teeth and default clauses around it to make sure that it's clear what needs to be done, when it needs to be done, and what flows from it if it isn't done. So that part of the process should be relatively streamlined. Then the question is, well, what if we can't agree? What if we haven't reached an agreement? Which is sort of where I preempted at the outset. The goal is, it's always a win if you're able to reach an agreement. However, if the other party is being so powerfully unreasonable and the costs are proportionate to commencing proceedings, if the gap is hundreds of thousands of dollars, it's going to be proportionate and sensible to commence proceedings because you're going to still end up ahead. So that's where litigation comes into the mix. Again, you can't just jump into it. You have to have exhausted all possibilities for having tried to sort it out for yourselves. Litigation's expensive, it's stressful, it takes a while. Courts undertake to try and get through a matter from first filing to a final defending within 12 months. Not to speak poorly of our beloved court, but it's a bit of a mixed bag, to be honest. Some cases are whipped through quickly and some still take years to go through. So it's there. There's a time and a place for litigation. We're very happy and comfortable and confident in litigating for our clients. But we just consider that if that can be avoided and still get a decent outcome for our client, we consider that a better outcome because you're just chewing into your assets by paying lawyers in litigation. So time, place. Option 2, arbitration. Arbitration wasn't really a thing until a few years ago, and I'm not sure that it is really a thing. It kind of depends on which jurisdiction it is. I know that there was a particular judge in Parramatta that was massive on arbitration and was flicking a lot of matters to arbitration. What is arbitration? It's kind of like a less formal court experience. So an arbitrator makes the decision for you in terms of the division of the asset pool. And I guess the pro around arbitration is that you get to pick your arbitrator, whereas you don't get to pick your judge. It's meant to be slightly less formal and slightly faster and potentially slightly cheaper than litigation. But it's not a breeze and it's not a walk in the park. So I've had mixed experiences with arbitration, and not saying that it couldn't be a good fit for a particular matter, but probably typically litigation. If you're at loggerheads with someone, anyway, we'd have that conversation with the client at that point in time. as I keep saying, the final comment there is to say arbitration and litigation, anything that takes the decision out of the party's hands is a calculated gamble, because there are no guaranteed outcomes in family law matters. The true win is to be able to reach an agreement early on. You can only control your bit and what you say and do. But I think that that's helpful to keep in mind in terms of the ultimate win in a matter. So, and it's our jobs to help clients make informed decisions and feel empowered through that process, and understand, well, what is the alternative if I don't accept this offer, or I do make that offer, etc.? What am I staring down the barrel of, or otherwise? And if the alternative is, well, it is, we're 500K apart, yeah, maybe it is worth litigating, and we will help you do that process. So time and a place is the short answer. That brings me to my next point, where I'll invite some questions, and thank you to the people that have typed them as we've been talking through that last slide. So I'll just start working through those now. Again, I'm not going to name names for the sake of preserving privacy. Okay, question. If you have children, what percentage do you get of your assets if you are the mother and taking the children with you, and the husband has the kids, say, every other weekend? I can't answer the question in terms of, say, for example, it's blanket 10%, it's blanket 2%. That being said, the tip, it's a future needs adjustment factor that's considered. And in my experience, the tips that we see for primary parenting, which is essentially what we're talking about here, are as little as 2.5% if the kids are old, because you don't have much parenting left, apparently, or as big as probably 10% is the upper end of that range if your kids are young, and therefore you've got a lot of parenting left to do up your sleeve. So 2.5 to 10% is the short answer. But again, I'll put a caveat on that to say there is no black and white, and it's a matter of tailing that to every case, but generally it's in that ballpark percentage tip. Next question. For a friend, not for me, how can you stop your husband from lying and declaring an income from his business way below what he actually earns? What documents would prove what he actually earns? His accountant doesn't show his true income. Happens all the time. Look, I've had a matter where we've had to, it was a construction business. So you kind of have to do a bit of detective work, and maybe they keep a hard copy manual tax invoice book, or maybe it's a matter of looking at the volume of material that they're purchasing, which then you try and argue, well, that correlates to this much work. Or maybe it's saying, well, you went on 15 overseas holidays, where did that money come from? So it is doing a bit of detective work. The other party's evasive by nature. And so is it easy? No. Is it doable? Yes. Does it happen all the time? Yes. Are the courts used to it? Yes. It's doing a bit of detective work around it. It would be a matter of speaking to that particular client and say, can you help me to point in the right direction of where we can dig? Like, is there a subcontractor that he always uses? I'm being sexist here in saying he, but I'm just adopting your example. I would be asking the client to say, where can we dig? How can we get some information? That can be done by way of subpoena or a notice to produce on the party involved in the proceedings. So hopefully that instills a little bit of hope in the situation. Moving on. What percentage of women do you find can actually afford to buy a house on the Northern Beaches after divorce? When should they look to see if they can buy a house for themselves and their kids? When they come to you and get their numbers straight away, so you know what they need to be able to buy, and you negotiate this as part of the process? Or what do you recommend to clients? Excuse me. Good question. My goal at the end of an initial conference is to tell the client, what the range of percentage entitlement is, for example, 55 to 65%, and then take it one step further and say, okay, and I'll say to the client, what's the dream outcome for you? And it might be, I'll just adopt this hypothetical, or maybe it's retaining the house or buying a new house. Let's say it's retaining the family home. the client might say to me, look, I'd really love to keep the home. I'll then say, okay, if you keep your home, your car, your savings, maybe your super, you'd have to take over the mortgage over the home. The other party would be keeping the super, the business, hypothetically, obviously, the publicly listed shares. What does the percentage division work out to be on that basis? And if that was, for example, that the party keeping the home was retaining 70%, they would need to pay a 10% cash adjustment to the other party to make that 60-40 division work. But in doing that exercise, I will then calculate for the client to say, therefore, given that your asset pool is, hypothetically, 2.5 mil, you need to pay them 10%. You need to come up with 250K. Please go and consult a mortgage broker to see if that is viable. So I do try and I try and understand from the client what the dream is, what the ideal outcome is, and try and come up with ballpark, but nevertheless pretty decent figures to work with, so that you can consult a mortgage broker to see whether or not it's worthwhile spending time and energy on that option. To answer your early question of what percentage of women, look, if I put it really crudely, a house on the Northern Beaches, or if you've got a family, you're typically needing more than a 2-bedroom unit. Not to say that you can't live in a 2-bedroom unit as a family. Let's face it, we're looking around, the market slumped, 1.5-ish. Therefore, our net asset pool, and dependent on the wife's or the husband's earning and therefore borrowing capacity, is within an asset pool of upwards of 2 and a decent earning income capacity. I act for a very varied range of clients and demographics. So I see plenty of clients that are able to rehome on the Northern Beaches, and some that are stuck in the renting cycle. Sometimes, and it might be ambitious or altruistic, we're able to sort of use the argument to say, excuse me, look, our entitlement might be 40%. Therefore, we can't afford to rehome on the Northern Beaches. We're going to have to go relocate to the Sunshine Coast, the Central Coast, somewhere more affordable. That's going to impact on the ability for you to spend time with the kids, because logistically we're not going to be around the corner. Can you come to the party and help us out a little bit by paying more child support or giving us a more generous property settlement adjustment? It's not a legal argument as such. It's a heartstrings argument. But if the parties are invested in trying to stay on the beaches and be able to maintain a relationship with their kids, sometimes it works. So I would unpack that with the client. So hopefully I've answered your question. Okay. Next point. I know someone whose husband moved all of his assets into his girlfriend's name and then the wife got nothing. How can that happen? Not digging enough. That's terrible. That part goes back to the disclosure step. So the way that we would try and tackle that is you would ask for copies of bank statements. And I like to ask for copies of bank statements the longer of going backwards 12 months or from the date of separation. So if you've been separated for 2 years, I'd say I'd like 2 years worth of bank statements, please. If a client said to me, look, we were on the rocks for 6 months before we actually separated, we had 200K in our joint account, but then by the time we actually separated, there was only 100K in there. In that scenario, it's a joint account, so maybe I should have said an account in just the wife's name, for example. On that basis, then I'd say we need to ask for bank statements that go back further than that. So the disclosure request process is the short answer. And then once we've identified that those monies have been squandered, dissipated, siphoned off, etc., the court used to notionally add back assets. They've moved away from that now, and they say, no, we just want to deal with the reality of the asset pool. but we're going to tweak the percentages to make that division just and equitable. So it might be a smaller pool, but the person who got diddled, if I can put it that way, they might get 80% of that pool to try and rectify the siphoning off of money. So I'm sorry that happened to your friend. Detective work around the disclosure process would be the way that I try and combat that. Okay, guys, I'm conscious that we've got 10 minutes left. And so at this juncture, I'm going to invite my colleague Janine to take over just to present a hypothetical fact scenario, which hopefully will make the law make a little bit more sense in a hypothetical scenario. So handing over to Janine, I'll let you steer from now. Oh, you're on mute, Janine.
Yes, I just realised. Thank you. Hi, everyone. I'm just going to dive straight in. So the hypothetical here is Ben and Alice have been in a relationship for 14 years. Ben is 39 and Alice is 37. Ben and Alice have 3 children, Ava, who is 10, Lucas, who is 8, and Grace, who is 4. Before having children, Ben and Alice agreed that the parent with the lower income would stay at home with the children until they were in high school. Ben and Alice purchased a property 7 years ago with an estimated value of $2.5 million, and the mortgage is $100,000. Ben and Alice live separately and apart in the home and have done so for the last 2 years. Ben sleeps on a pull-out bed in his home-based office. Ben had no assets at the beginning of the relationship. He worked as a tradesman in his small business, Ben the Builder. Ben earns about $170,000 per year. Ben works long hours from Monday to Friday, leaving home at 6 a.m. and arriving back home at about 7 p.m. in daylight savings and 6 p.m. in winter. Ben also works on most Saturdays. He prepares his invoices and orders materials for jobs at night, spending an average of 7 hours a week on invoicing and ordering. After the purchase of their current home, Ben did unpaid work, constructing a second level to the house, which he estimates added at least $400,000 to the current value of the house. Ben spends every Sunday with the children, and also on Sundays he does the lawn mowing and cleaning of the front and backyards, washing the cars, and on a monthly basis washes the outside of the house. Alice had an investment unit, which she says was worth $500,000 with no mortgage at the commencement of the relationship. Lucky Alice had been gifted the unit by her wealthy parents. Alice had a career in marketing prior to the birth of Ava and was on a substantial salary. Alice estimates that she was earning 45% more than Ben when she was working. Alice has not worked since the birth of Ava. Given that she has been out of the paid workforce for 10 years, Alice considers that she would only be employed in a low-paid job. Since Ava's birth, Alice has done 90% of the parenting. Alice also says she has done 85% of the housework and cooking. Alice concedes that on Sundays, Ben does the parenting role and does do work on the outside of the house. Ben and Alice are both in good health, and the children are in good health too. Ben may receive a modest inheritance from his surviving parent, his mother. Ben says that his mother is in good health and in her early 60s. When she dies, the sale price of the house will be shared between Ben and his 4 siblings. Ben estimates the house is worth about $3 million. Alice may receive a substantial inheritance from her parents. Both her mother and father are in their 80s and in poor health. Alice has 1 sibling, and the estate of her parents would be worth about $7 million. Once Ben and Alice are no longer living under the same roof, Alice is likely to continue on as primary parent, given Ben's work commitments. It is likely that he will eventually spend time with the children from after school every Wednesday to drop off at school on Thursday, and alternate weekends from after school Friday to drop off school Monday. That is 5 nights a fortnight. Ben has about $240,000 in superannuation. Alice has about $86,000 in super. Alice has the following additional assets: a small collection of jewels worth about $10,000, a car worth about $8,000, her investment unit worth about $1.5 million. Ben has the following additional assets: his work truck worth about $28,000, his shares worth about $35,000, and his collection of toy cars worth about $15,000. Ben and Alice have a joint bank account from which the mortgage and living expenses and the children's school fees and expenses are paid. Ben has a business credit card with a debt of $18,000, and Alice has a credit card debt of $3,600. Ben estimates that his business is not worth anything other than the truck and the tools of trade, totaling about $33,000, less the business credit card of $18,000. Alice is a discretionary beneficiary in a family trust set up by her father. Alice receives a benefit of $12,000 per year from the trust, but these payments could be stopped by the trustee of the trust at any time. Ben wants the home sold. Ben says that he should receive or retain 75% of the net proceeds of sale of the house, his super, his shares, his truck and business, and be responsible for the business debts, and his collection of toy cars. Ben says that Alice should receive or retain 25% of the net proceeds of the sale of the house, her super, her investment unit, her jewels, and she should be liable for the credit card debt. Alice does not want the property to be sold. Alice says that the children need stability, and staying in their home will provide them with that stability. Alice says that Ben should receive or retain a cash payment from her representing 40% of the current value of the house, about $960,000, his super, his truck and business, and be responsible for the business debts, and his collection of toy cars. And Alice says that she will sell her investment unit or borrow from her parents to pay out Ben, and she should receive and retain the home, her super, her jewels, be liable for her credit card debt, and refinance the mortgage over the home into her name only. So a question for you guys to consider. Given what you've heard in this session, do you consider Ben or Alice's proposal fair or neither? Sorry, Beck, I think you're on mute.
Anyone want to have a crack at being a lawyer? The purpose of what we were trying to demonstrate in that hypothetical is no two families, no two stories are the same. It's a matter of understanding the details and the intricacies of each and every relationship and the dynamics and contributions and future needs around that. And working out a deal that's just and equitable. So again, it's a matter of providing tailored advice to the parties and the particular situation. No one wants to be a lawyer. Shame. Fair enough. I do have one further question before I move on to resources and contract. The question is, if you want to get a property out of your name and give it to a family member before you are classed as a de facto, what do you need to do in regards to getting a valuation? Can you use the valuation from the land department, how rates are determined for the land, or do you have to pay, new question popped up in it. Or do you have to pay a valuer / real estate agent? Let me just reread that question. Right. So if I've understood it correctly, just to paraphrase it, before you hit being classified as de facto, you transfer real estate out of your name into a family member's name. Can you go off the value that's used by the Valuer General's Office for land tax purposes, or do you have to get a formal valuation? We're in tax duty world now. I'm not an accountant, I'm not a tax expert, but I'm pretty confident what the tax issue is that you have to get a valuation, because if the transfer is not done at arm's length for market values, you've got to pay stamp duty on the higher of market value and the agreed value. Janine, agree, disagree? Yeah, she's nodding.
Yes.
Yeah, so, and sorry, your question was, can we go off the Valuer General? Short answer, no. Unless the value that you've agreed to transfer the property, if there's no consideration being paid, clearly that's below market value. And Stamp Duty's office will say to you, you guys need to get a valuation, and you pay stamp duty on the valuation value. Question: if you have a private unknown account, i.e. secret account, which many of my friends have, say you don't declare it, but he finds out anyways and you've not declared it, can you actually get into trouble for this, i.e. fraud, or do you just have to declare it and split it and you're not in any trouble? You're in trouble. From a biting it in your butt perspective, Section 79A of the Family Law Act basically says that if you cut a deal and you enter into consent orders, the other party is allowed to file an application to set aside those orders for failure to disclose a material non-disclosure of a relevant asset, or material fact is the wording. So don't do it. Full and frank financial disclosure. It's got to be disclosed. You're probably likely to be entitled to keep it, but it's got to be disclosed and it's got to be in the pool and included in the mix when we calculate and crunch our final numbers. Otherwise, you leave yourself exposed to the other party making an application to set it aside. Same kind of logic applies if you're entering into a BFA instead. You can make an application to set aside the BFA. So no is the short answer. Guys, I'm conscious of the time. It's 9:01 and it's a Wednesday night, so you probably want to go to bed, which is completely fair enough. So I'll finish up by just drawing your attention to the info on the slide. So just some resources that you guys might find helpful and informative. If anyone would like a copy of tonight's slides, very happy to share that with you. Our firm's also recently published a relationships report, which is just intended to be interesting and topical. It talks about everything around statistics of divorce, average ages of kids, but then also in more, I guess, topical or contentious stuff like IVF and surrogacy. And it's just an interesting read in your non-existent spare time. So if anyone would like a copy of that, an electronic copy of it, please shoot us an email. I've listed our contact details there for myself, Kathy Chase, Janine, who's presenting tonight as well, and our lovely paralegal, Glenda Johnston. If you're old school, we're located in the BizTech building in Dale Street in Brookvale. Otherwise, you've got the phone option or just Google us. So, guys, thank you. Thank you for your comments and participation and attendance tonight. It's really appreciated. I hope it's been helpful. You've got our contact details. If we can be of assistance, we'd love to hear from you. Otherwise, have a good night and thank you, guys.